Good morning and welcome to another edition of the Daily Fix. I am your usual host and presenter, Advocate Tulo Hoyani. As arguments for the defense and the prosecution came to a close yesterday, I picked up one or two issues which are of paramount importance as those addresses unfolded. And I want to give all due credit this morning to Advocate Numalo for his, relentless and committed attitude in the way that, he has prepared for this matter. And thanks to Advocate Numalo, a lot of things are coming to the fore, which would otherwise remain, unseen or not taken care of. Now, those arguments really revolve around, you'll recall, whether or not Advocate George Baloyi can use the confession statement of accused number 2, Bongani Ntanzi, to cross-examine Muzi Sibiya about the about the confessions or the details of the confession that Ntanzi is supposed to have made significantly to Magistrate Cronje. But before I get into that, and I'll bring you a clip where I'll show you both these two things. The first thing that I want to bring to your attention is the fact that during the ruling in the trial within a trial, Judge Ratha had indicated when he made that decision. You remember that flip-flop decision that was not even written, that Judge Ratha just delivered off the cuff of his honorable neck. Judge Ratha indicated in the judgment when he dismissed the application for discharge of accused number 4, Mapisa, that the evidence of Zungu remained unchallenged in the Pretoria High Court. That is why he believed the single evidence of Constable Zungu. But yesterday, Advocate Ngumalo brought it to his attention that in fact the evidence of Constable Zungu had been challenged under cross-examination, not only by him, but also by Advocate Mnisi. So it was a huge error on the part of the court to say that the evidence of Constable Zungu had gone unchallenged by the defense, when, as a matter of fact, Advocate Ngumalo referred Judge Ratha to the proceedings of the 3rd of October 2025, when this actually took place, as reflected in the court record itself. Judge Ratha sought to play this down and said, well, that is a peripheral issue. In other words, peripheral in the sense that it is not an important issue. He sort of, just brushed him off and said that we all know that Zungu is a single witness. But what is of importance there is Advocate Ngumalo had shown him the big mistake that he had made when he made that ruling. Because one of the most important things that he had referred to is the fact that Zungu's evidence had gone unchallenged. The second issue, which I'll come back to just after this clip which I'm going to play, relates to whether or not these are executive statements or whether what Moses Bongani Ntanzi made is an executive statement and confession. And all the advocates there strenuously argued, all the defense advocates strenuously argued, and convincingly so, that it is a confession, and that a confession, as a general rule, or confessions as a general rule, are either admissible against co-accused. They are an unequivocal admission of guilt, but such admission only operates against the maker of the confession statement, not his co-accused. Just take a listen to this before we continue.
Yes, but one would want to find that since Zungu had questioned Gwabeni about the pointed-head revolver, then that amounted to corroboration.
Who says that?
By implication.
Who says that?
That is what I could read
No, fine. That's why I say who says that?
From the court's judgment. That is why I'm raising it now.
No. There's got nothing to do. It's a peripheral issue. Zungu is a single witness. We all know that.
Yes.
Yeah.
Yes. But I just wanted to highlight that.
I hear you.
I just wanted to highlight this. This was done under cross-examination.
Yeah. But just read it for me, Alun. Just read that cross-examination.
My lord?
Just read that portion.
Yes.
With regards to the fact that the firearm was thrown into the water, what?
Yes, thank you, my lord. It's the record of the 11th of September 2023, on page 97, line 18. In fact, it's cross-examination by my colleague, Advocate Jimenez.
Yeah.
And I quote, "Thank you. The very same Kwabene that you have told this court about will also come and tell this court that whilst you were in his room at the hostel, you further asked him if, after being handed with the pointed-head special firearm, you asked him if that was not the firearm which he said he threw away in the river after shooting at Sinako, using it." Then the response by Constable Zungu was, "I did ask him that."
Okay. So if I say that, it's a mistake.
I also, because my cross-examination followed, my lord, on the very same subject, because I was not happy with the response that was given by Constable Zungu.
Yeah.
On the 3rd of October 2023, it's a record of the 3rd of October 2023, at page 34.
Yeah.
Line 15. In fact, from this passage, my lord, I was quoting from the statement of Constable Zungu. I will start from, I'm sorry, my lord, I will start from line number 9, which read as follows. This is a quote, my lord, from the statement of Constable Zungu, Exhibit AA of the record. "I then took the pointed-head special firearm from Gwabeni's hand and looked at it. I asked Gwabeni if it was not the same firearm which he had said he threw it away in the river after shooting Snako, with the close quotation. Mr. Zungu, I hear that." The interpreter, which line is that? Mr. Ngumalo, it is line 9 and 10. Okay. But my lord, it's just a long passage, but I wanted to re-emphasize the fact that this issue was canvassed under cross-examination. It will appear from page 34, 35, 36.
Page 34, 35, 36.
36, 37, and 38 of the proceedings of the 3rd of October 2023.
The 3rd of October, ne?
Yes, 3rd of
2023.
October 2023.
Fine.
So, my lord, in conclusion, then, I submit the following. It follows, my Lord, therefore, that accused number 2 statement that he contested was made after his arrest on the 16th of June 2020 is a confession statement. It is a narrative of the past events and not an executive statement made in the furtherance of a common purpose or conspiracy, and cannot by its use as directly or indirectly against the co-accused in cross-examination.
Okay.
Those are my heads, my Lord. They are dated the 7th of November,
7th of November.
2025 in Pretoria. Thank you.
Okay, thanks. Yes, madam, are you ready?
Yes, I'm ready, my lord.
Sorry, Mr. Omalo. Do you know the Omalo since Soweto?
Omalo Soweto? No.
Okay. You don't know the famous drum reporter who exposed the atrocities perpetrated on black peasants? They were farming potatoes using their hands.
Was it Umali?
Yeah,
No, I'll follow on that.
famous gentleman.
Yes.
I schooled with the daughter of Suzette.
Is it?
Pretty girl.
When was that?
Hello?
When was that?
Suzette, I schooled with her 1960
Oh,
in Madibane High. And the father, who, but a wee reporter, he was a reporter, as I say, Idram and Zong. And he's the guy who trained Abu Net Nakasa. You must know Net Nakasa.
yes, I've heard.
Yeah. They hounded him out of South Africa and he went to teach in Swaziland. I must SBs. You must ask your parents about the guy.
No, I will.
Abaninanga abuzi aboduna musa.
It shows that we spend most of our time in Zululand, so
Is it?
Yeah.
Okay, no problem.
thank you.
It just struck me. Yes, ma'am. Nasive. You haven't written hits.
No, my lord. I will address from the...
No, I'm just asking.
Yes.
Yeah,
My lord, in response to the application by the state, my lord, I would like to respond as follows. Generally, my lord, the confession in terms of section 217, it's inadmissible against the co-accused. That's the general rule, which is also confirmed in the case of S versus Molim, 2008, volume 2, SACR 76. It's a constitutional court decision.
yes, Bankabinde.
By Kabinde, my lord. It's a standard rule which confirms the provisions of the criminal procedure and the constitutionality of those provisions.
Right.
That the use of a statement against the co-accused is unconstitutional, my lord. In this case, my lord, this honorable court has ruled on the admissibility of the statement that is an issue. And when the state introduced this statement informed this honorable court that they intended to introduce the statement which was referred to as a confession, and the other one was referred to as a pointing.
So to round up the issue, it is very clear that this is a confession. And I can also take the argument further to say that it would not be in the interest of justice to use such a confession against, or to use it to cross-examine Muzisi. I don't think it would be in the interest of justice to do that, and would be severely prejudicial to do so, because remember, this is a disputed confession. And even if Muzisi says, well, I'm not even disputing that the confession was made, I'm not disputing that, although we all know that the confession is disputed by its alleged maker, Bongani Ntanzi, accused number 2. Even if that confession was made, let us assume, just for argument's sake, that it was made, it cannot be used, Muzisi contends, to cross-examine him, and thus to implicate him in whatever is contained in that confession statement. So my gut feeling is that is how things must go. That we have seen how things go in that courtroom. And in a later edition, I'll be giving you more assessments into the possible outcomes of that ruling, which is coming our way on Monday. But these are the two most important issues. So Judge Ratha made a huge mistake in his ruling regarding the discharge of accused number 4, Mapisa, when he said that Zungu's evidence had not been challenged by the defense, when in fact it had been challenged on 2 different occasions. That is a big mistake that he made yesterday, that Advocate Ngumalo brought to the attention of Judge Ratha, and he was visibly not pleased by it. Having said that, let me thank you for watching this video. Let me thank you for all the views and subscriptions and shares that I'm seeing. Let us march on to the 12,000 subscriber mark. That will be a huge, huge, huge Christmas present for me. Make it happen. Everything has happened because of your support. Thank you, and have a wonderful Saturday.